Good afternoon and welcome to our January regular meeting of the Buncombe County Board of Adjustment. Welcome members of staff, board, and the public. Appreciate you being here. We'll move to announcements from staff today. No announcements, okay. We'll do a roll call, starting with Mr. Mazelis, and then staff.
Joe Mazelis.
Paul Wozinski.
Craig Allen.
Andy Ball.
Greg, you're up.
Gabe Quisenberry. Mark Diaz.
Jason Payne.
Dana Alley.
Savannah Glantz.
Kurt Euler.
Griffin Kearns.
Thank you very much. We do have minutes from the December regular meeting, is that correct? Those have been gone out by email to board members. Any thoughts, comments, edits, motions?
No comments. Motion to accept.
Motion to approve the minutes. Is there a second?
Second.
All those in favor, please say aye. Aye. Any opposed, nay? That passes. Thank you. Move to disclosure of ex parte communications or conflicts of interest. To clarify there, any member of any board exercising quasi-judicial functions pursuant to North Carolina general statutes shall not participate in or vote on any quasi-judicial matter in a manner that would violate any person's constitutional rights to an impartial decision maker. Impermissible violations of due process include, but are not limited to, a member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, closed familial, business, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. So we'll go around and just make those disclosures now if we need to.
No.
When I was coming up on the elevator, I had a very brief ex parte communication directed toward me. He did not know who I was. It will not affect me.
Okay, sounds good. Council, be okay with that criteria? Okay, thank you.
No, none.
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 None. None.
Thank you very much. Moving to public hearing section, we'll start by outlining that this is a quasi-judicial evidentiary hearing, and that means similar to a court hearing, state and local law set specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision upon the competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and standards and not personal preference or opinion. Matters of personal knowledge and specific facts are acceptable, but opinions on traffic, speculation on impact on the community regarding crime, et cetera, other issues, are not. We value a transparent process and encourage the community to remain engaged and participate. But given this is a hearing on the record, there are certain topics and areas that limit the type of testimony we can receive from members of the public without standing, so as a witness. Expert testimony is defined for us for certain topics as the board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic stemming from the proposed project. Individuals providing expert opinion testimony must be qualified as experts by the board and provide the factual evidence upon which they will base their expert opinion. As a reminder, witnesses should provide factual testimony as to how the project does or does not meet the standards. The board must base its decision upon evidence in the record and not personal preference or opinion. Moving today to one of two cases, ZPH 2025-00032, the Villa Variance. This is continued from the December 10th, 2025 meeting. Last time we heard this one, we continued it.
Chair Ball,
Yes.
before we get moving, I believe that we have interpretation services for this, and they would like
Yes.
to make a brief statement.
Please.
Can I also make something to everybody in the audience? Please make sure that your cell phone is on mute. There are a lot of people in this room today, and so in order to keep going, we don't want a lot of interruptions. So if you have a cell phone, please turn it on mute. We would appreciate that. Thank you.
And thank you for that.
Thank you so much. We have interpretation today. There will be Spanish spoken by one of the participants, and we gave simultaneous interpretation to all of the members here, and we will be interpreting live simultaneously during that process. So if there are any questions, you can just come to the person that's not interpreting at the time. But for the members here, once you hear Spanish, in order to hear English, you'll just turn on the device as it was instructed to you, and then Spanish can also be spoken in the audience as well.
Thank you very much. We'll start with staff report.
Please raise your right hand and state your name.
Jason Payne?
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, Jason.
Thank you very much. This is a review of ZPH 2025-00032, the VIA variance. The applicant is Walter Lucas of Titan Factory Direct, and the property owner is Pilar Via Chacon. The property is located at 90 Hazelwood Road. The total acreage of the property is 0.28 acres. The property is serviced by public sewer and municipal water. The property is zoned R3, and the applicant has applied for a variance to the zoning ordinance of Buncombe County 78-642 for dimensional requirements to allow a front/right-of-way setback reduction of a dwelling unit from the required 10 feet to 4 feet, so a difference of 6 feet. The request is being made to allow placement of a home on the property. The site plan here provided by the applicant shows the property. You can see the proposed location of the home. You can see its encroachment into the required setback line there. And like I said, that's an encroachment of 6 feet. Does anyone have any questions?
Board questions for staff. Seeing none, I think we're all good. Thank you.
Would like to say one more thing. I'm sorry. So it's a little hard to read on this survey, but you can see that the back half of this property, there's a line there that is a Progress Energy right-of-way that is there. So that is what that line is saying.
Is that back from the curve or back from either side?
It is on the western or the eastern part of the property. Let's see, right here is the line.
Right. Okay.
Hazelwood Road would be here on the curve.
Thank you.
And that was all I had. Thank you.
Thank you. Did we admit staff report and everything?
Oh, you know what?
Yeah.
I missed that section. I'm sorry. I also missed certification. I apologize. So I certify that this public hearing was properly noticed and all applicable parties were noticed of, or notified of the meeting in accordance with the general statutes and county code. And I ask that all applicant staff materials be accepted into the record as evidence.
Hearing no objections, so accepted.
Thank you, Chair.
We will move now to our standing portion of the hearing before we get started with the applicant to ask if there are folks here wishing to assert standing in the matter. I believe we have one that we know about ahead of time on file here, the application for Ms. Lytle.
Yes, good afternoon.
Is that right?
Yes, I'm
Feel free to approach, sir.
Oh, I'm sorry. Boy, so strong, I didn't know I needed that. And say good afternoon, and thank you all for this opportunity. Yes, I represent Ms. Lytle, and Ms. Lytle is a property owner. She's the next door neighbor on this piece of property. I think we uploaded at the prior hearing that it was canceled and rescheduled, all of her information. She owns the property on both sides. Where are you, Ms. Lytle? Come up. She is the property owner right next door to this lot.
Why don't you,
I do it any way you want.
we'll have her testify.
Okay, go ahead.
Up there.
You can
So
tell
there-
them.
And then Jean, you can,
What's your lot number? Tell them your lot number.
well, hold on, we need to get her sworn in first. And
Yep, that works. I'll sit.
Just to be clear, which one of you is asserting standing?
I am.
Ms. Lytle?
Ms. Lytle?
Thank you.
Yes, I'm her attorney. Thank you.
Thank you.
Yes, sir.
Yeah, we're going to get her sworn in, and he will examine her.
Welcome, Ms. Lytle. We'll swear you in.
Thank you.
All right, please raise your right hand and state your name.
My name is Chrissy Lytle.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Thanks for being here.
Thank you. Ms. Lytle, you are the property owner right next to this lot, is that correct?
I am.
What is your address?
Mine is 96, and the property that's in question is 90.
And you own a second piece of property there
I do.
also? What is that address?
That's the 92.
And how long have you been there?
I have been there 26 plus years.
Okay, and your property is directly affected by the motion for this variance, is that correct?
That is correct.
Called deterioration to your property?
I'm just going to have you, sorry
Oh,
to
I'm
interrupt.
sorry.
I'm going to have you hold the microphone to your close end here.
Okay,
We
is
can all
that
hear you.
better?
Thank you.
You would think a referee would know how to do that.
I just blow the whistle.
So you've been living there, and there's been deterioration to your property because of work that's been going on there on this lot.
That is correct.
And we uploaded, have you all sworn her in yet?
Yeah.
Can we get those photos uploaded?
Mr. Ellison, I just want to make sure that you are establishing her for standing and that she has special damages, different, separate
Yes.
and distinct.
That's exactly right.
Okay, I just want to make sure we're not getting into your case in chief. Thank you.
Again, you have suffered special damages because of this application for a variance and some work that's going on. Is that correct? Speaking to the microphone.
That is correct.
There's been some digging that was going on without a permit being granted that affects your property. Is that correct?
That is correct.
There's a driveway that you all have been using for 20 years that comes around the back of your property. Is that correct?
It comes down to the property from the top that is no
And-
longer there.
And what kind of digging has occurred and what has happened?
The digging is approximately 14 feet deep. It has deteriorated down into my yard, and you can no longer access my property to get to my property.
And that also included some power lines back there that there was a right-of-way for, is that correct? Or water lines?
There was a power line that went across 90's property.
And that would belong to Duke Power?
That would be.
And was that affected by that? Was that power line damaged?
It was damaged, and I had to make a 911 call to Duke in order for them to come out and put this line back together because of the hazard.
And that digging that created, it's kind of a crater that has been created that does not allow for EMS or any other vehicle to get by, is that correct?
That is correct.
So it created a safety problem there also, is that correct?
That is correct.
And in addition to that, the hardship that's been created where they want to be able to have the line, instead of requiring 10 feet, they want it to be 4 feet, was created by this digging, am I correct?
That is correct.
And so with that, they want to move it closer to the front. The concrete on the front has started to deteriorate in front of the property and your property, is that correct?
That is correct.
Explain that to the board.
Okay, the concrete that is there now that's present was the driveway on top of my property. Now the dirt that is up under that concrete is now eroding and running down into the yard, and it is no longer access for me to come down to the property. So in that, EMS could not get in. I have been rushed to the hospital twice. That's how we know EMS could not get to me. The stretcher would not come down that embankment that was there to have access to the property. They could not access that. So in this hardship, we turned around and put stairs on the opposite side of where the bank was. And we put stairs there, but the stairs was not even wide enough for them to get a stretcher down. So they physically picked me up and carried me up the stairs to get there. And then once we got there, it was very hard to turn around because that we turn around or back up onto the end of that property no longer exists.
Now, prior to the illegal digging out of the back of this lot and that crater, EMS was able to get in and out of there, and safety was not an issue. Is that correct?
That is correct.
That property also does not have access to water. Is that correct?
That is correct.
All right. Those would be my questions.
Board questions?
Yeah,
Hold
Chair,
on,
please.
hold on. Is the applicant here? Yes. Does the applicant, could you come up to the, all right, do you have, as the applicant, do you have any questions about this witness regarding standing?
Yes.
And we'll go ahead and swear you in too at this time.
I'd like to raise one question. Who is the applicant? He says he's the applicant. Is he the applicant, or is the young lady the applicant?
She's the applicant, property owner.
And he's not an attorney, so my question is that who's going to ask the questions of my client? Is it going to be a lawyer, or is it going to be a person that's accompanying her that's not a lawyer?
I mean,
Who's gonna ask your
Mr. Ellison, in these cases, normally, I think you raise a valid point as to that. Normally, we have in the past historically allowed design professionals, architects, engineers, things like that to present applications on behalf of an applicant, and we haven't had any unauthorized practice of law type questions. Obviously, if you would object to, I think that I agree. I think it should be the actual applicant and not the design professional asking questions regarding standing.
That is my objection.
Okay. I think the design professional can testify in the case in chief, but I don't think the design professional can act as an attorney in this
That's right.
proceeding.
That's correct. Yeah. So sustained. Yeah. So we'll have you, ma'am, ask questions. Yeah.
I'm sorry.
And we'll swear in at this time.
We're not allowed to ask. I don't think anybody needs to be sworn. The applicant does not need to be sworn in because she's not testifying at this time. If she has any questions of the standing applicant, she can ask them at this time.
So we'll swear her in before her presentation? Yeah.
Yes, we'll swear in at a later time.
Y'all can get comfortable, have a seat if you like to. And
So-
you may ask questions of the.
So,
Can I ask the question?
no.
No.
You have to ask the question.
So, ma'am, if you have any questions for this witness regarding her standing application, now would be the time to ask those questions.
We need the interpreter here.
Okay.
¿Usted va a hacer una pregunta? No, porque no entiendo de qué dijo. Dice que si usted tiene una pregunta relacionada de lo que acaba de decir, que no sé qué dijo. ¿No está escuchando?
Ask her if there's, she said there was no water available on her lot.
Entonces, algo de lo que yo no escuché nada. No lo está escuchando.
No dice.
Okay, so what happened here is she was not wearing the interpretation equipment, so she did not hear what the person said. Is there a
Okay.
possibility for it to be repeated so that she can hear that and be able to ask a question? She was just not wearing the equipment when the session was starting.
Who wants to summarize that?
Van a hacer un resumen si usted quiere prender el equipo y escuchar y van a hacer un resumen de lo que ella dijo. So she does have the interpretation equipment on now, so if there is a
Okay.
summary that can.
Just to be clear, we're going to keep all comments to the standing application, not to the actual specifics of the case. Yeah.
Would you like me to summarize?
If you want, if you'd like, yeah.
So,
let's do
ma'am,
that.
and Mr. Ellison, correct me if I'm wrong, but it seems to me that they're alleging special damages based on the digging that prevents EMS from allowing the standing applicant to access her property, for EMS to access her property, and that those are special damages that are separate and unique from your other neighbors. Is that a fair assessment, Mr. Ellison?
Yes.
Thank you.
And also the digging of the crater without the permit, the digging that created that
Right.
situation has caused property to deteriorate.
That would be the second special damage, that the unauthorized digging has created other problems separate and unique from the rest of the community. Okay, so it's not unpermitted digging, but the digging on the property is still, okay.
But it may have interrupted services to your property, is what I'm hearing.
But I think the main thing is that EMS can't
That's the main
access
thing.
a property.
Mhm, yeah.
Yes.
And so if Ms. Lytle has any questions, sorry, not Ms. Lytle, I'm sorry. If the applicant has any questions for Ms. Lytle, this time that would be appropriate, about the standing piece.
Moved into the property line. Más bien, lo que ella ha hecho durante todo este tiempo, ha usado el terreno que ahora yo compré y que es mío.
Oh, sorry. Puede volver a repetir eso porque no lo traía puesto ahí. Y si quiere puede usar el micrófono para escuchar un poquito mejor.
Me acerco más.
Ajá. Lo puede agarrar y si usted no
Oye.
oye.
¿Cómo es así? Dios. Ahí.
Is everyone on the party listening?
Que no se ha hecho ningún daño, no se ha excavado en terreno que sea de ella. Más bien lo que se ha usado es, ella ha estado usando todos estos años el terreno que ahora compré yo y legalmente es mío.
Anything else this time, Mr. Hunt? Anything else this time, Mr. Hunt? Yes. Okay, this time we'll ask the board if they have any questions for Slidell. Yes, Paul?
Yeah, Mr. Chair, can I just clarify something with you before I ask a question? We're looking to see if the applicant for standing is going to suffer damages because of our issuing this variance, right?
Because
That's
of the
the point.
project going forward, yes.
Okay, so anything that happened in the past has nothing to do with this, right?
Correct.
Okay, so I'm gonna ask, I'm gonna say, we can't consider anything that you said about anything that has already happened, okay? We have to start from the date that the variance is issued, if it is issued, and see if there are, if you're saying there will be damages in the future because of the issuance of the variance. So if you could tell us what damages you anticipate happening from today forward, not from today backward.
Okay. Looking forward, if it is allowed, I am going to suffer again, almost landlocked. I will not be able to get the property out if I choose to put something new in. I will not be able to sell the property because you're going to have to use, as a letter he put in, a crane, or I'm going to have to use, or they're going to have to give part of the land back in order to even get the property out of there, okay? Again, my most concern is the unsafety part of it, because that property, if you give the variance, is going to cut off access to the property, and it's going to be a safety issue where EMS, EMT, any type of emergency vehicle could get in. It's also going to cut out the other properties that may come in from that end of the property to even bring another mobile home or anything in, because that swing, that curve is in, will not give you access to turn. So someone would be down on top of their property and it landlocked mine so that I could not get out or ever put anything else in it.
Okay, but let me I just want to be clear about something. Are you currently landlocked?
Right now, the way it's standing, I would not be able to move anything
Okay, so you are currently landlocked.
in an aspect, yes.
Okay, and as of today, EMS is unable to enter the property, right?
Correct.
Okay, so that's where we are right now. That's where we have to start.
Okay?
Okay, what, in addition to that, what damages are you going to suffer above and beyond the status of the property right now?
Right now, the property is going to be less valued.
It's going to be less valued if she puts the home in than it is today?
Yes, sir.
Okay, why will it be less valued if she builds a home than it is today?
Because for
With the
my,
variance of 6 feet in, yeah. Is that right?
that is correct.
Okay. Yeah, okay.
Yeah, but I don't understand.
So.
I understand that's your
Can I
assertion.
clarify the question for you? I think what another way to say it would be, going forward, if the variance were granted and the 6 feet, and the house were moved that 6 feet, how would that moving of the 6 feet impact your property negatively?
Even
What you're
move-
alleging here. So
Even,
how would that-
even moving 6 feet more, okay? You even close me in the more, okay? You also even take more land that was there, okay? It crosses over into my property. We're line to line, so there is almost no giving. So you even make it a bigger hazard moving forward because you're coming even closer to the line, which make it even less accessible.
Okay. Just so, I don't want to assume anything here, but just I want to get clear in my head. The residents of this community own the house that's placed there. They also own the lot.
Correct.
Yes? Okay, they're individually owned. Was there a legal right-of-way on the driveway that's existing now, that's now deteriorated or been taken down, whatever, accessible? Was there a legal right-of-way for your access? Was that a legal driveway?
No, it was not.
And where was your legal access to the road? Was it directly on the road?
It was directly from the road down to the property, okay? And even saying that, as I understand, that property was never meant to be a lot
That she's on or that you're on?
that she now owns.
Okay.
I have never dealt with Miss Vallis. I have never dealt with her. I always dealt with her son-in-law, Henry. Before that property was ever purchased, I talked to him several times because there was 4 to 5 others that tried to purchase that property, and it was not allowed to put the size home that they're saying to put on it, okay? I talked to Mr. Henry, which is her son-in-law, I talked to him. I said, make sure you do your homework because they won't even allow us to back our home up because of the power lines, all of that.
Okay.
There was never any digging, never.
Okay.
And so with that, even if you look it up, that was a fourth lot that was just supposed to be whatever. When I talked to the realtor, they told me that only thing that could be put on that lot was a 1-bedroom, 1-bath. That's what I told Mr. Henry. He said, oh, no, we're not getting a large one. It's just my mother-in-law. Okay? So once the digging started and it came all the way over there and the bank and all started eroding, I came to the board. I tried to get information on what I needed to do. Okay? I talked to erosion. And the lady that was at the front, she told me she was retiring in 2 days. So I didn't get the information for someone to come out and see what was happening.
Okay.
He continued to dig. And I said, well, this have now caused an issue because the whole entire bank, even where we're parking, is eroding. The water stands up in my yard, everything else. So it was never, ever, as I talked to everyone in the community, it was never meant to be a lot
Okay.
or a large home.
On
to
your
be
lot,
put on.
though, on the representation you're making today on your lot is that that when you bought it, the deed, the ownership deed, had a legal right-of-way for that driveway to access the main road that you sit on through a different lot than yours.
Correct,
Okay, and that driveway's now been compromised.
correct.
Okay, got it. Any other board questions for Ms. Lytle? Yes.
So moving forward, if we grant the variance, are you still landlocked?
Even the more.
Any other board questions? Okay. Thank you so much, ma'am. Well said, yeah. Anything else to follow up with across? Nothing else? Okay, all right. We'll close the public hearing on this standing application and have board deliberation.
It's not entirely clear to me what the future harm is going to be that hasn't already occurred.
I think a current harm can be a continued harm. Is what I would say to that. So because the condition already existed doesn't mean, and it continues to exist after the variance is granted, it'll still be a harm. So she's alleging a harm. She's alleging a future harm. Is that accurate to say?
I think the key is whether the applicant suffers special damages distinct from the rest of the people. I mean, we keep saying that. And yes, I think that the past harms, if those past harms are remedied and can't continue, that I would not recommend considering them. But if there's a possibility that past harms are still, it's an ongoing issue, then I think that should count in your decision-making.
Sure, yeah, okay. All right. Any thoughts on standing then?
Motion to accept standing.
There's a motion to grant standing to the applicant. Is there a second on that? There's a motion and a second. All those in favor, please say aye. Aye. Any opposed, nay? That passes unanimously. Thank you.
Okay.
So at this time, we'll move to the applicant's presentation first, and then we will have an opportunity for your presentation second, and then we will go ahead and have a cross-examination opportunity before the board asks questions each time.
Okay.
Make sense?
So am I allowed to speak now?
So we'll start with the applicant there, yeah, absolutely.
Okay. Do I need to be sworn in?
You do?
Yes.
Please raise your right hand and state your name.
Walter Lucas?
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, sir.
Okay.
Mr. Chair, can I ask a question?
Please.
What role is Mr. Lucas taking in this? He's not an attorney, right?
No.
So
He's not speaking for it either. He's helping present the case. Helping the applicant present the case.
I think he is a design,
He's
I'm
a
not
hired
sure,
professional,
maybe
yeah.
you can explain to us what
Sure.
your qualifications are?
I work for Titan Factory Direct. We sold Miss Villa her home, and we obtained the permits the site plan review, all that for this property
Okay, so
before
you're
they
testifying as
purchased
a
it.
witness then?
No, he's an agent in the bill that is assisting her in the application presentation. He's allowed to do that.
Oh,
He's
okay.
not allowed to cross-examine people.
Okay, gotcha, thank you.
Yeah.
I
Thank
would
you,
think
sir.
that we would treat him like we would like any other
Any-
witness.
Yeah. Thank you, sir. Sorry for that. Yeah,
Okay.
please.
Yeah, so we got a timeline. I downloaded it on the, if you want to pull up the timeline of how we purchased this property with Ms. Villa. So the property was purchased after we did a site plan review, got approved by the county, and then we went ahead and got the permit. Then they purchased the property. And then from there, we started the land disturbance, only to find out later that the surveyor did not include a right-of-way. And that's why we are here today, because the property where the house was going, that was approved in error through the site plan review, did not include that right-of-way. So that's why we're asking for that variance today. Prior to that, we didn't have any confrontation with the lender or with the neighbors. The homeowner's insurance did grant us the water availability for this property, and we went ahead and started construction, only to find out later that we needed this variance. So upon the fact that the neighbor said that they could not get their house out if they wanted to do in the future, I did have, and I downloaded that into the portal as well, a signed letter by one of the most respected mobile home movers in the area, Johnny Connard, who said that, yes, he can get that out when the house is there. There's plenty of room to remove that house. So that, that statement was probably not true. Anyway, going forward, so we would like to have that variance to proceed with Ms. Villas, because now she only closed on the loan because of the site plan approval and because she got the permit. We have closed on a loan that will, if she does not go through this loan, she's already going to be $25,000 to pay out, to get out of this loan due to closing costs. So she has incurred financial distress because of this wait period. The construction period has ended, and now she's paying interest on this loan that has not been fully executed. So with that, that's kind of where we are, and I'll take any questions.
Questions?
Hold on, I think you give Mr. Ellison.
That's right. I was about to, yeah. Mr. Nelson.
Thank you very much.
Do you have your microphone?
Yes, sir, thank you. Yes, sir. Now, let's be clear. You own the mobile home, and you're selling a mobile home to her for this lot, is that correct?
That's correct.
That is your role here, is that you, without her getting this variance to go, she can't buy the mobile home from you, is that correct?
That is correct.
And so, that lot size is .28, is that correct? acres
Without
that-
looking at it, I'm not sure what that lot size is.
I mean, you know, it is zoned for a one-bedroom trailer. What size is the trailer that you are selling her to put there?
It's not zoned for a one-bedroom, it's zoned for just that particular size, whatever can fit in there.
What size trailer, sir?
That's
are-
a
are
20.
you selling her?
It's a 24 by 52.
How many bedrooms is that?
That's 3.
So it's a 3-bedroom trailer that you're wanting to put in this space. And you're asking for a variance of the setback to go from 10 feet to be reduced to 4 feet to be able to put that home there. Is that an accurate statement?
We are asking for the variance because the site plan review was approved in error.
I'm asking you, sir, you're asking to reduce the 10 feet setback to 4 feet
so the mobile home will fit there. Is that an accurate statement?
That is accurate.
And the reason that that is necessary, because the digging that went on is so close to the line that you no longer can set it back. It has to be moved forward. So the hardship of getting it there was created by the digging, whether permissive or not. It was the digging out of that back lot that created that crater that requires you to come here today to say, hey, we want to move it up.
No, it was only because the right-of-way. There was a
Well-
right-of-way that wasn't in the original site plan
Let me ask
review
you-
that they did not, when they
Before-
approved it.
Before you put her under contract to sell this mobile home, did you go out and measure the lot?
Yes.
Well, did you not notice that what the setback requirement was there
No.
before you sold her the lot?
No, because the site plan got reviewed when it got approved when we submitted it.
Well, my question to you, sir, you're asking the board to reduce that setback from 10 feet, which is substantial, down to 4 feet to allow this to happen. Am
The
I
set-
accurate?
No, the setback was based on the right-of-way of what's in there now. It wasn't there when it wasn't, the right-of-way, the setback from the right-of-way was not reviewed during the first approval of the original site plan review.
Well, that would not be my client's fault, would it? Would
And it's not our fault either.
Well, let me ask you this. She is the fourth owner in about, 2 years of that lot, trying to put a trailer in that space?
I'm not aware of that.
You're not aware of that?
Let's keep it relevant to current matters here.
All right, thank you. Have you noticed the deterioration that has occurred since the digging went on?
No, there's grass growing there now.
What about the concrete that has been cracking and the flooding that has been going on the lot? Have you addressed that?
No, I haven't seen any of that.
Have you been out there to look?
I have.
You indicated to this board that you have someone that told you that they could go in there and do whatever's needed to remove it. Is that person here today to be questioned by the board?
He is not, but he's got a signed, it's loaded in the portal. It's a signed statement.
But he is not here to be examined or cross-examined about anything that he's written.
He is not here, no.
And so the only hardship we have here is that you will not have a sale if this variance is not granted.
No, that's not true.
Well, I mean, that's why you're here, sir. Am I right?
No, I'm here on behalf of my customer who is suffering financial hardship if this is not, variance doesn't go through.
Well, your customer had the right to have a lawyer, have a title searcher, and to look at this piece of property prior to purchasing the mobile home from you. Was that done?
We had all the site plans done. We had the permit done before we went to closing on the lending.
I have no further questions.
Board questions, start with Joel.
Yeah, I've got a number of questions. Well, first of all, for the applicant, sorry about your surveyor, okay?
Yeah.
You should have gotten a better one.
Yeah.
Question, you keep talking about a permit and site approval. Who approved the site to put that home down?
Yeah, the planning department of the county.
Planning Department of the county. And is that document on here?
Yes, it's loaded up in the portal. It was approved on 8/7 of '24. It was submitted, actually. The zoning permit was issued on 8/27. We did get a zoning permit for that. The building permit was issued on 9/24. The proof of water was 9/26. Proof of sewer was 10/11. We closed on the loan on 10/18.
And for reference, that download is titled APP Disclosures.
Okay, well, to stay in that stuff, I got some other question, but
Please, yeah.
for the staff, you said approval by planning or zoning.
Yeah, let me Let me provide some context here. So the site plan review was approved in error. The site plan showed the right-of-way line. It did not show the setback off the line. The plan reviewer missed it. The building permit was then applied for and then issued. The building permit then lapsed and expired. Upon review of trying to renew the building permit, it has to go through our review as well. They don't have to get a new site plan review, but we have to sign off on that building permit. And that's when we caught the error, that the site plan review was approved in error, that we can't sign off on this building permit renewal because it doesn't meet setback. So that's why we're here for this variance.
So in other words, the site plan was approved in error by the county. Is that correct?
Initial review.
The initial review, correct.
Okay, okay. Well, my question, when it was initially approved, was the mobile home bought after the initial approval by the county?
Yes, they closed on the loan. We ordered the house on 10/21, and then the house has actually been sitting on our lot ever since.
So the mobile home was sold before the error was caught,
That's correct.
okay? Basically, some of the digging, okay, I guess you asked about the damage. And, you're saying that the digging has caused damage on her property, including the concrete. Is that what?
And we have photographs that's been uploaded for the board to review. I don't know if you all have seen those. But the photo. No, he was asking me, I'm sorry.
Yeah.
Mr. Mayor.
Okay,
Ellison, we need to focus on the one witness.
okay. Have you seen the photos that they presented of the damage on
I
her
have.
property?
I have not.
Okay. Okay, that's,
Can I respond to that?
Does everyone have it printed? Not this time, sir. Does anybody have it printed out? Or it's online, we know, right now? So
They're uploaded.
they're uploaded. So
They're
online.
uploaded in the standing application for Lidl. You'll see us, documents with the application.
So they're in the materials for today. Yeah. Okay, so they haven't seen them. So
pardon?
they haven't seen them, they said.
Order.
Oh, that's it.
Okay. So to be clear from that exchange, you all pursued a conversation on a sale for this home with initial approval from the county, and then subsequent to entering a contract for the purchase of the home, and the loan application started, all of that. At some point after that, the county came back and said, okay, it's not okay by the setback line.
Correct.
Okay, got it. Other board questions?
I've got questions regarding the document, the app disclosures that include the permit and surveys. There are two surveys that are in this document on page 7 and page 8. And if you could please look at those and give me an explanation of why the proposed house site that is noted as subject to county planning approval, as denoted on page 7, is within the required setback. And then on the following page, page 8, it is repositioned and it is now conflicting with the setback. How and why did that change occur?
So the initial one did not show the right-of-way with the setback.
And if I'm reading this right, I'm not a surveyor, but I don't know that the right-of-way is relevant to the proposed position of the house as denoted on page 7 or page 8.
So from my knowledge, there's a 10-foot setback from the right-of-way rather than from the original property line. In other words, the original property line runs through the middle of the road, and I believe that's 25 feet. And then, but there is a right-of-way before that, and that has to be 10, and there, the setback has to be 10 feet off of that, and that cuts into our original site plan. That's why we're asking for the variance. The house hasn't moved from the original site plan. I think it was just the survey's interpretation of where the house is going, just to see the setbacks, I believe.
Am I the only one seeing that, Mr. Chair?
I can't find where there's a difference between the frontage on Hazelwood Street in front of the property, where the setback line's missing in one of them. They look the same to me.
Okay.
So, I mean, if something pointed out to me, I'm happy to look at it, but.
Yeah, I agree with you, Andy. It looks like the same preliminary plat, which the dates are, I think, the 5th. I can't read the first one, August 5th and August 8th are the dates on that plat. So I'm not, but I don't see, yeah. They're basically the same preliminary, not recorded plat.
But I can't pick out what's changed in between the two.
All right, and I will withdraw my question if you feel satisfied with that.
Other comments, questions from the board?
Do I have an opportunity to?
Yeah, you may.
Just a couple of questions, because I want it to be clear. The point was made about the building permit that was issued expired. Can you tell them, sir, the date that that permit expired?
Yes. It was 3/24 of this year, of last year,
3/24 of what year?
2025.
And you indicated that if the permit was issued and expired, then the permit no longer existed after the date. Am I correct?
The only reason it expired is because we couldn't get any inspections done due to this.
I didn't ask you that you didn't get any inspection, but that permit that was issued expired, you said in March of 25?
That's correct.
And so it didn't have anything to do with the closing and the selling of this particular mobile home, is that permit expired. Whether there was a clerical error or oversight that was made on that, it was corrected when the petitioner tried again to get a permit, and they realized that it didn't fit. So it has nothing to do with her closing on this house, is that permit itself had expired, which means that there was a fresh application, and there was a review of it, and they caught the error, and they caught that error for a good reason, is that this is just not a place for a variance. That 10 feet to 4 feet.
Mr. Ellison, can you ask questions as opposed to testifying? We need you to ask your question.
I've been known to do that, I'm sorry.
You can save your arguments for closing, but we need you to ask questions.
You're worse than the judge.
Habits have it. Habits have it.
I'm sorry, we're trying to keep things on.
I just want to finish up that if 10 feet to 4 feet is what you're asking for, is that correct?
I'm asking for a 6-foot variance into the 10-foot setback.
But that 10-foot setback existed at all times when you all had surveyors and attorneys prior to anything happening to look at this. Am I correct?
Not to our knowledge, no.
Not to your knowledge, but you're not a surveyor or
That's
an
correct.
attorney.
That's correct.
And all you're doing is selling a mobile home.
That's correct.
Nothing further.
Can staff clarify that piece for us real quick on the date or approximate time frame of the discovery of the setback and notification to the applicant? So not after the initial approval, but after that when you discovered the issue? Approximate month of that.
One moment.
Was that a question for me, or is that?
For staff, yeah.
Okay.
And while we're looking that up, for the applicant, what was the date of loan application?
The loan application,
I'm looking at a contract prep document dated 7/25/24. So around then, I assume.
the actual application was done on 7/2/24.
7/2/24?
Mhm.
And then one more date, and that's the date of acquisition of the lot. I presume in these situations that your company buys the lot.
That was the closing, which was, I believe, 8. Hmm? 10, was it 10/18? We closed on the loan on 10/18.
Was this
24.
when was the deed for the lot put into your company's name, I presume, to?
We don't put it in our
You don't
name,
do
it goes
that, okay.
into the loan lender.
When was it sold to the applicant then?
That would have been 10/18/24.
The deed for the lot, okay.
Mhm.
And yes, Mr. Payne.
So I can testify that the building permit expired April 11th, 2025, but I can't give a time frame as to when the re-review happened. It happened during an office visit. It would have been happened after that time, of course, but I do not have any recollection or cannot give an accurate time frame beyond that.
Okay. Thank you so much for that. Joel?
I got some questions. Even though someone's not here, it's listed in your document. One of the things you say, HOA stopped us from delivering the mobile home to the site. You want to comment on that or explain that?
Yes, so so originally, the HOA has a gate in the back that they open to allow the entry to that area. When we were set to do footers, we got a call saying, we're not allowing you to proceed with your set. So we had to cancel the footers and everything. And that's where we found out that there was an argument against the property with the neighbor. So
the HOA has taken action?
HOA informed us that they weren't moving forward with the sale with the construction of the home on their lot, on that lot.
Wait, they opposed it, but have they taken any kind of action to stop you, to clarify that?
Yes, they wouldn't allow us entrance to that gate to get a home in there. Is that what your question was?
Okay, so that's it. They won't allow you any entrance to that.
Correct.
gate. That was the end of it. Okay. The other thing, too, you're representing the applicant, but your company manufactures the mobile home, right?
That's correct.
So in some ways, I guess you have a financial interest if this home is sold?
Well, we have the home in our lot, okay? Financial interest would be, whatever contract we have with the customer, Miss Villa. If it's more to the fact that if she doesn't get this variance, the lender's still wanting this, if she has to back out of that loan, they're still wanting the closing costs for that loan, which is about $25,000.
Okay, but
We can sell the home to somebody else, not a problem.
But you.
But we don't want to do that.
But you're the seller, right?
Right.
Okay, so you, I guess, got paid for selling a commission or something like that?
It does, but like I said, our interest is getting her into her home. That's what we do.
One last question I have I'm sorry, were you finished?
No, I was just saying that's what we do.
One more question for the
One
app.
last thing.
Please go ahead.
Let me bring it up again to make sure I'm clear. Mr. Ellis submitted photos of damage to her property over the line through the excavation. Now, you said you haven't seen these, or you haven't seen the photos that were submitted?
I haven't seen the photos that was submitted. I have been out there. I haven't seen any damage to her existing property. In fact, I think some of the driveway is actually going over into Miss Villa's property.
But is any going onto Miss Lido's property?
I haven't seen any erosion or anything like that, no.
Okay, well, have you brought out a surveyor or something to make sure the excavation didn't affect her property?
Yeah, so the excavation was done by another, it's not done by us, it was done by another contractor, contracted through my customer.
Okay, so essentially what you're saying, the contractor knew where the property lines were.
That's correct.
Okay.
As part of preparing the site plan for this, what, have you planned a driveway to access this property on this lot? And if so, where is that?
Yes, so the driveway is planned on the other side to 90, I guess it's 92 or 94, so that would be 86 or whatever it is. So that's on the site plan review. It's going down that little hill, and then there's parking. I believe they require an 18 by 18 pad for this particular site.
And that'll be on the, as you're looking at this plat, on the north side, the northern boundary of the curve, to the left side of the home as it faces the road.
No, it'd be actually on
I
the
don't have
south
numbers on
side.
mine.
The parking would be on the south side.
Show me. Okay, that's all I've got. Anybody else?
Yeah, I just have one other curiosity question, back to this HOA issue. If I understand that conversation about the HOA, they're not allowing you to do work that's necessary for this project to become completed.
That is correct. And that was after they gave us approval. They gave us a water approval, and they gave us approval to move forward until this happened, yes.
Okay, and I realize you can't testify on their behalf, but do you have any reason to believe that if this variance is granted, they would give you permission?
I'm sorry, what was the question?
Do you have any reason to believe that if we granted the variance, the HOA would give you permission?
I do, because I think this is, well, there again, I mean, they they did give us approval to start with, and now this happened. I don't see why they wouldn't if we have all the permits.
Was the variance the reason for the HOA's action, or was another reason the reason?
The original reason was that she thought she couldn't get her house out if she needed to.
No, sorry,
Before
what's the
we
reason,
go
what's the
down-
reason the HOA gave your client, no, sorry, not your client, the applicant, that they couldn't let you proceed?
They thought that when we put this house in, that they could not remove the other house that was the neighbor's, which was her house.
The HOA said that they couldn't remove it?
That's their
Or the
whole
contractor.
argument, was that they thought that if we put this house in, we could not remove that other house if they choose to do so.
Members of the board, before we go down a rabbit hole,
Right.
I think that it's not really relevant to the variance as to what the HOA is or is not
Right.
going to do moving forward. I think we need to focus solely on whether or not there's reasons to grant the variance, and then if there are problems moving forward with the HOA, that would be between the applicant and the HOA.
Are there any more board questions for the applicant? Yes.
Has there been any discussions with Ms. Lytle to try to come up with a solution to this?
Yes, there has. I believe Henry, which is the son-in-law, has made sure that they have access to her entrance, and to make sure that anything that we do with the house, he was willing to work with her on that.
Whether any of the solutions proposed would prevent her, as she said, from being landlocked?
Yes, I mean, I think she's not landlocked based on the fact that our mover said that they can remove that house based on there's 18 feet of clearance to move that house. She only requires 14 to 16.
Okay, I have just one more. This is for Ms. Lytle. If we could translate,
We're
yes?
still on the witness. Wait till the.
Sorry, what?
We're
I'm
still-
sorry, I
We're
mentioned
still
the wrong name, I'm
examining
sorry.
the applicant when the.
That's right.
I think that then when the.
I misspoke.
Standing.
I misspoke.
we-
The question's
okay.
for the applicant. I need a translator.
Okay,
So,
so- I'm
thank you.
sorry.
If we could have the translator come up or translate the question. Okay. Sorry. Well, okay. Ma'am, did you hear from the county about the setback issue, the problem with the setback, before or after October 18th, when you entered into a contract for the loan in the house? Did that information come to you before you entered into the contract for the purchase, or after you signed that paperwork?
Ms. Chair Ball,
Yes.
I don't believe that the applicant has been sworn in yet.
Please do.
Okay.
Okay.
Ma'am?
Please raise your right hand and state your name.
My name is Pilar Vila.
Do you swear or affirm to tell the truth and nothing but the truth?
Sí, lo juro. Thank you. It's very heavy.
Thank you, ma'am.
Pues yo no sé. Primero que nada, yo no estoy al tanto porque estaba hecho cargo el esposo de mi hija, pero él en este momento está fuera del país. Pero quiero leer toda esta hoja, si es que es posible.
Sure.
Muy buenas tardes, mi nombre es Pilar Villa. Estoy aquí ante ustedes debido a un permiso aprobado hace un año atrás, ya que habíamos llenado todos los documentos necesarios para revisar si el terreno 90 Hazelwood era apropiado para asentar una traila double wide, y recibimos la aprobación de ustedes. Con esta aprobación dada por ustedes, pude obtener un préstamo que cubría mi terreno y la traila juntos. Estaba muy feliz de que finalmente mis ahorros iban a ser usados para tener un hogar para mi vejez. En octubre del 2024 fui a vivir con mi hija, lo que empezaba el proceso de tener mi casa, pero desafortunadamente empezaron los inconvenientes con mi vecina, presidente del OA, al decir que no podía poner mi traila y que no me iban a permitir a menos de que haya un acuerdo. Porque la vecina usaba mi terreno durante 30 años. Estaba confundida, ya que al tener la aprobación de ustedes, no sabía que iba a haber ningún inconveniente. Me fue dicho que sería demandada y decidí buscar ayuda legal en marzo del 2025 con el abogado Eric Contre. Todos estos meses hemos estado tratando de buscar un acuerdo, pero el desgaste financiero y emocional ha sido demasiado de lidiar. Mi salud ha empeorado. Sufro depresión, estoy enferma. Todo empeoró cuando ustedes nos dijeron que habían aprobado el permiso de mi terreno por error. Fue ahí que sentí que ya no podía más con toda la presión y mi depresión está peor. ¿Cómo es que esto suceda? Las consecuencias han sido tantas y sobre todo sobre mis hombros. No tengo un lugar donde vivir y tengo una deuda que pagar. Nadie quiere hacerse responsable, nadie quiere perder dinero. O sea, toda la carga está sobre mis hombros. Si ustedes no hubieran dado un permiso por error, entonces yo hubiera buscado otro terreno en donde no tuviera que lidiar con nada legal ni con nadie que no me permita ingresar a mi tierra. He sido humillada. He gastado tanto dinero imprevisto de alrededor de $27,000, sin contar con lo que debo pagar a mi abogado. Estoy abrumada, estresada y siento que es injusto todo esto para mí. Este error suyo ha ocasionado daños a mi salud mental y ha afectado físicamente también. No puedo dormir, no quiero ni trabajar, no tengo hambre. Aunque hoy ustedes solucionen y me den un permiso, tendré que continuar a llegar a un acuerdo legal y lo que ha afectado a mi salud mental, ¿qué queda con eso? Si yo no puedo asentar mi casa y mi tierra, quiero saber quién va a ser el responsable de regresarme todo el dinero que he gastado y que tengo que pagar. Soy una ciudadana, soy una mujer honesta, trabajadora. Y jamás he estado envuelta en nada ilegal. No es justo que me sienta discriminada de tener una tierra en la que no puedo tener mi casa y haber pasado tanto estrés por un error que alguien cometió. Solo pido justicia. En estos momentos, con referente a mis vecinos, debido a esto del variante, están esperando también estos resultados para ver que haya la posibilidad de sentarnos y hablar para llegar a una solución. La idea es construir una fundación al nivel del camino. La fundición sería alrededor de 10 pies. Una barda de retención será construida y vamos a llenarla para tener 16 pies para un espacio o una entrada y salida para carros en caso de emergencia, porque pues las ambulancias no se necesitan todos los días. Porque esto es lo que mi vecina está pidiendo para dejarme asentar la traila. Gracias.
Thank you so much for the statement. We appreciate that. Do you recall in October of 2025, October 18th, signing the loan documents to enter into a contract on the property? You can respond verbally if you
Sí.
can, yeah. Sure. Do you recall on October 18th, 2025, entering into a contract to sign those documents for the home purchase?
Sí. Sí.
And at that time, when you signed them, had you been made aware that there was a problem with a setback that you didn't know before?
No, no.
No. Okay,
Todo
Thank you.
estaba en orden.
thank you so much.
Ya, bueno.
Any other questions from the board? Joel?
For the applicant, who hired the original surveyor?
So the original survey came from I believe it was a copy of that whoever was selling the land to Ms. Billa had that survey, and we used that. We didn't have our surveyor go out there, no.
You did,
No.
but the seller had a surveyor go out there?
The seller of the land had a survey that we used.
Do you know what the date of that survey was?
No, I do not.
Do you know whether it was recent, last 10 years, 20 years?
No, we just used that as the premise for the site plan review.
Do you have a date?
No, from what I look at, it's from Heron and Associates, but I can't read a date on there.
There's no date on it.
If there is, I can't read one.
Okay, who relied on the survey of the lot? Was it you as a manufacturing representative, or was it the actual applicant who relied on the survey to purchase the mobile home?
So they provided the survey for me, and I did the site plan review based on that.
Okay, so that was you. Yeah, thank you.
I just would like to make one clarification. I'm looking at the timeline that was submitted in the documents, and they closed on the loan in October of '24. Is that correct?
That,
Which attachment name are you looking at on the? Thank you, yeah. Is that it?
Yeah, correct. Mhm.
Okay, thank you.
So my clarification being, all of this happened before the permit expired. The loan was closed, the permit was issued. So looking at this, they would not have known until March of the earliest of '25, when that permit expired.
Would not have known what? That the permit expired?
That there were issues with the setbacks. Because that's what generated the reissuing of a permit.
My understanding was that that was the spring of, when they were notified by the county, it was the spring of 2025 that there was an issue
Correct.
with.
Yeah, yeah.
But they don't say, there's not a date attached to that. So
But
they had already acquired the property, is what you're saying?
Yes, they had already closed on the loan in October of '24, so the permits were all given in good faith, and they acted on that good faith to then get financing for the house and close on that loan.
Okay. That's correct. According to the timeline, that's correct.
Okay.
Yeah.
May I-
Yes, point of information.
Can, okay.
Yeah, we'll finish up here real quick, yeah. That's, according to that, that looks correct, yeah. Any other board questions? Okay. Any, based on the statement that the applicant gave, do you have any cross?
Yes, thank you. There was, I think, the most important question asked in the last 30 minutes was just asked by one of your board members as to how they had planned to get the mobile home on the property, and they were denied access. I want to know, was she aware that the property that they needed to come across belonged to Ms. Lytle, my client, and that's why no agreement was reached? There is no right-of-way to come. The only way they could come, they would have to have her permission, and that's the permission that was denied to come along with the HOA. You aware of that, ma'am?
You answer that
No.
question?
No,
We served, at one time, you were represented by Attorney Contra when this application was pending, and all the documents that we uploaded, we served on your lawyer that included all the photos of the damage and also a list signed by every resident of that neighborhood. Did you have an opportunity to look at the objections of all the neighbors, the HOA, and my client? Have you seen those through your attorney, who's not here today, Attorney Contra?
mi abogado no está presente porque él no es especialista en variance.
But he was the lawyer that you were using.
Well, I think to clarify this, you can maybe clarify the question that whether she received the documents and reviewed them.
Let me clarify the
Yeah.
question. The lawyer at the time that this petition's been pending, that the lawyer for Ms. Lytle was dealing with on this issue, was served with all the photos of all the damage, all the exhibits that we have today. I'm asking you, did you see those documents?
Sí, pero o sea, no hay ningún daño. Los daños que dice él, o sea, en todos estos años, la señora, mi vecina, ha puesto cemento, no sé cómo se dice, en lo que es mi terreno ahora. Si es que hay algún daño, es de lo mío, es de mi terreno, más no es de ella. Está usando lo que es mío.
Ma'am, were you made aware before you closed on this property that you needed my client's permission to be able to get that mobile home on this lot?
No, porque o sea, yo compré un terreno, me dan las medidas y pues es algo mío, sino como ella a los 4 compradores anteriores que ha habido, no les permitía por nada. Y yo, si hubiese sabido que no permitían comprar, asentar la traila, yo tampoco hubiese comprado, si hubiese sabido. Por eso hay tantos compradores, porque esta señora no les permite a nadie, no les ha permitido que asienten ninguna traila ahí, porque quiere para ella.
And so you were fully aware
Sí.
of the problems that exist prior to you closing?
No, ahorita me entero que dicen que ha habido 4 compradores antes.
And so that's not Ms. Lytle's problem. That is the problem for you and the seller of this mobile home.
No, porque pues, o sea, yo compro algo, si compro algo es algo de uno, ¿no? Es del que compra.
I agree with that statement, but however, do you agree that had your lawyers or your surveyor done proper title search, they would have seen there was no right of way to get this trailer on this property, but for an agreement with Ms. Lytle? Because they had to come across her land. And so there's no way to get this trailer
Es que
on
no
that property.
no atraviesa el terreno, no atraviesa. El terreno de ella está adentro, lo mío está acá, no atraviesa. No. No atraviesa.
Nothing further.
Thank you both. All right, so at this time, we'll ask if there are members of the public who wish to speak on this matter. And as we do, we'll, yes.
I think the first thing would be is to see whether the people was standing or whether the standing has, if they want to present any more evidence.
Yeah, that's right.
Or
But not a
first
closing
thing,
statement, yeah, okay.
Does the applicant have any more evidence or testimony that they want to present?
All I can say is, we don't need her permission to get we're not going over her property. We're going through a gate and a road that goes directly to my customer's property. We're not touching her property whatsoever.
And this is the time in the hearing, if there's anything else you might want to add to support your case, you can do that now. I know she already read a statement, so it's probably her case in chief.
No, I'm good.
Anybody else you're going to call up or anything?
All right.
All right, Mr. Ellison.
Yes, I would like to call my client.
Okay.
You've been sworn now. And I'd like to refer the board to the documents that's been uploaded on behalf of Ms. Lytle, and we'll make this pretty straightforward and brief. Ms. Lytle, there were a number of photos uploaded. Would you like to grab these? Can you see them? Can you see the photos from on the computer? Can you see them?
I can.
Just each photo, go through and tell the board exactly what's in each picture.
Okay, that was piece of the property that allowed us to get to my property. So that where the vehicle is sit is where the entrance was to get down to the property.
Next photo.
Okay, that is my property. As you can see, how that the bank is eroding and it's going down into Miss Fire's property. Okay, and with that being said, this is an older one that has washed out even the more. That was when gravel was placed down.
And that is continuing to wash out, is that correct?
Correct. That looks like a repeat.
Can you establish who took these photographs?
Did you make these photos?
I did.
And,
I did.
And so you were the photographer for these?
I was.
Okay.
I was.
Yeah, thank you.
Here you see where the ground has started to erode even the more. And here I showed where we put stairs to go down to the property from the top of the bank.
And prior to the digging, we haven't seen that photo yet, but prior to that digging out to that crater, those steps were not required, is that correct?
That is correct.
Go ahead to the next photo, please.
These look like repeats. Okay, here I was showing how that where the digging is coming into more of the crack of that bank, which is now, you see that crack, that now is completely over there, and it has pushed down into the yard. This is the bank I was saying EMS could not get down because it's no longer there. This is actually when the digging started and the line had been cut, and Duke actually came out and put a temporarily protection over my power line because it came across Ms. Vyer's property.
Did you have that problem prior to the digging?
No, sir.
It exposed, in a right-of-way, it exposed the Duke power line, which put a risk to your property, is that correct?
That is correct.
That power line also served your property, is that correct?
That is correct. It's same, that is the same as the power line being exposed.
Is that the crater that was dug out?
That is.
And so before that, that property was built all the way up. No, that hole didn't exist.
No, it did not. That property was built all the way up over to where you see that other mobile home and the car sitting. It was built up. Trees have been removed, dirt has been removed. All of it's just been removed, and now it's a big hole.
And when that digging occurred, tell them approximately how many trees were removed.
Ooh, probably a dozen. There were, where you see it the closest, the bank right there, that's the closest to you. There was approximately 3 large trees there, because when we put our mobile home in, it actually was what planning actually had me to do.
One question, how long have you owned your property?
26, 27 years.
Okay, go ahead, next photo.
Okay, here is where all the water is just washing down. It's just washing it out. You see where it was wider and it was just coming down. This is after a rain. That shows the crack in the bank that has now washed out. Down through there, as I understand, supposed to be where they moved the power line to. And that's the end of that one.
That's the end of the photos, is that correct?
Yes, that is correct.
Now, there are a few other documents that we uploaded. I believe there is a document 3 pages long with signatures from all the property owners there. Is that document there?
It is.
Excuse me?
It should be on the website, so.
Are you referring to Lytle's supporting documents?
Yes, it should be in the post.
So that would be
That-
C.
See, you see it?
I do not.
Hold on.
Hold on a minute.
So, no worries, you're doing fine. So I think he is talking about, not sure, there's all the deeds, Exhibit C. Are you referring to the neighborhood?
That's correct, the neighborhood, right?
All right.
Okay,
Thank
you
you.
see that document?
Yes, sir.
And if you're looking at that document, can you read the heading on that document? We do not want. Do you see that? Signed by all your neighbors? The homeowners
Yes,
association?
I do. It says, we do not want the fire variance to take place in Hazelwood. They did not go through proper channels and just got friends on there to dig until they dug up our power lines and left them exposed. That lot was not intended to have a dwelling place on it. That's why it has gone through several owners. This has been explained to them by several people.
And
We
that,
oppose.
all those signatures are the original signatures of everybody that lived there and members of the homeowner association, is that correct?
That is correct.
including the president?
That is correct.
Let's see, did you
Hey,
take a look? See
I do want to point out to the
Yes.
board that none of the people signing that petition
I
are
just-
here, and so I do, for whatever reason, that may be considered hearsay. So
Sure.
please take that as you wish.
Okay.
But if we consider that hearsay, of course, the testimony of a person that say they could take the crate out, you didn't say that then, that is also hearsay because he is not here to be examined. So as long as we get the same.
Well, no, I want it to be fair when you all are, but when people are submitting letters about and statements about what other people have said, come on.
Right, I
Be fair.
understand.
We are fair. We do not have to follow the strict rules of evidence, but we do need to point that out and
Can we
you
take them
made
at
your
the right
point.
weight? Yeah.
Yeah, but to be fair to me, you didn't say that when the gentleman said he had somebody sign that could come in and move it out. We have to take that for the same.
I have not objected to any hearsay I have not raised that issue regarding anybody's testimony, but when you're presenting documents, that is a very different thing. Thank you.
And we do see Ms. Hughes signing here, and that's the one that we see,
Appreciate
so,
it.
yeah.
You've been fair, thank you. So lastly, ma'am, they talked about bringing that trailer in. The interest where that gate is, who owns that property there?
I do. 96 Hazelwood own it, which I own.
And did anyone attempt to reach an agreement with you to authorize that?
Not to bring anything in. I do give the okay. And the thing is that I have not spoken to any of Titan's home. I spoke to Henry, which is her son-in-law. I spoke to his wife, and I spoke to Ms. Fires. I spoke to Ms. Fires and her daughter one time. And on that one time that we spoke, we tried to come to agreement, as they have said. We did. Each time, we have came to an agreement with attorneys and all out at the property. Henry reneges and do not do what he said he would do. That is exactly why we're here. He said that he's been out there at that property. I'm there all the time. I have not seen him. I have not seen him because from the time I spoke to Henry's wife and her mother, we have tried. They have moved the driveway from side to side, trying to get it in. I spoke to Henry, even on here where it's in color now. I had took a picture of him where he was leaving my house, talking to me, trying to actually come up with a way that we could make this work. And every single time we have tried to make it work, something comes up, or the house was too big, or whatever it was, we tried. I tried every which way. But every time we come up with something, even with the attorneys, something else come up that the house, we said, come up with a smaller house. I can't do that. Give me the right-of-way that's wide enough that I can get mine up out of here. He agreed to that and turned back around and said, well, the house won't fit. His wife and his mother-in-law stood out there with me and two lawyers and said, this is what we can do. I don't know if Mr. Titan came in and said, it's not wide enough. So I have tried several times to make it work. But to be clear, the property you're asking to come across to bring that house in belongs to me. So it's not HOA.
Nothing further.
Of the witness, and ma'am, we're going to have to probably put
Okay.
something in your ear to hear the translator.
I got it here. I got it. Thank you.
No, lo que quería decir es de la variance, lo que se tardó todo esto del permiso de la construcción, que no se hubiera caducado, ¿cómo decir? Si es que se hubiera llegado pronto a un acuerdo con la señora, pero como no se puede llegar a un acuerdo, conversaron los abogados, quedamos a un acuerdo, pero ella no llegó.
Hold on.
Y si-
Ma'am, this is your chance to ask questions of the witness, not to testify.
No questions, okay.
Do you have any questions of the witness? No.
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 Okay, thank you.
Does that conclude your questions, Mr.
Yes.
Okay, it does. Board questions.
Ms. Lytle, I have a couple of questions. The first photograph that was thrown up there that had the vehicle by the side of the road, there were some stakes in the ground that appeared to be in alignment with the property line, which then leads me to the question that I think was always out there. The driveway that you used to access your home before any and all of this bubbled up, was that driveway crossing your neighbor's property?
It was.
And did you have a legal right to use their property to access your mobile home?
No, sir.
If you had had the legal right, and if that were not an issue, would you be opposing this variance?
Would you repeat that for me?
If you had the right to access your property, if you had the legal easement, would you be here opposing this variance?
No.
So is it correct to say that this boils down to the right to cross someone else's property to access your home?
Yes and no. The yes is, I understand it's their property. The second part is no, is that it is destroying my property, and I have kept that property up for over 27 years. And the board, the planning board, back in the day when I got the property, had me to fix that property in order for me to access it. So the trees, the grass and all, they told me before they would approve me to move into it, that's what I had to do.
And is the issuance of the variance going to create any more problems to the earlier questions we asked early on about the erosion and the impact on your bank, the property that separates the embankment?
In my opinion, not an expert, yes, it's going to cause more problems because as in the pictures, I showed how wide it was at that given time. Now, you can't walk down that bank. There is no access whatsoever, and it's going to continue to erode.
Thank you.
Joel.
I've asked this before, I'm gonna ask it again to be sure. The excavation, and by what it says here, a friend did the excavation, and I'm unclear if he knew where the property line was. But the excavation, the damage shown in the photos, is this on your property?
It is Ms. Vyer's property that I kept up to access to get to mine.
Okay, so it's not actually on your property.
No, just the erosion is coming over onto the property.
What was done, what you showed, some of the erosion stuff, is that going to affect your property?
It is going to affect my property because it is affecting it now because the erosion keeps traveling over and over. It have crossed the property line where they said the front part of the concrete is. Yes, it is coming and it's washing out even the more.
Has the applicant offered to make any changes to stop, let's say, this erosion?
Yes, that was the agreement that we came to, Mr. Henry, because like I said, I have never dealt with misfires. And the agreement was he would put the dirt back and put up a retaining wall. That's what was asked. And with the retaining wall, that it would be enough room for me, because mine is 16 feet. And he said he could go 18 to 20. He then brought a surveyor out, and that is where you see those pins put at, of where he could move it and put it back, Mr. Henry, okay? The first surveyor that he talked about was an old client. It's where that survey came from. And that's where he said he went off of that. That person also backed out of it and did not get it because it had nothing to do with me. It couldn't be put there, or what they was trying to put there. But Henry and I have said 1,001 things of what could be done and what he would do. And every time it came that time, something else came up. The house was too big, to the point that he couldn't give me the 18. It came down to, I'll give you a little walkway. And I'm like, but a vehicle, emergency vehicle cannot get down here.
Can I get clarification? Can you show me a photograph that shows erosion and collapsing of land that is on property that you own?
Okay? If you, okay, can you put it up there for me? There we go. Okay, that's my land.
That
Okay,
is your land, but it doesn't clearly show the stakes. So
okay?
go to the
That
ones,
there.
go to where your driveway, the issue of your driveway.
This is the driveway that I had, that was there, that I accessed.
And where are the stakes that mark and note your property versus your neighbor's?
Okay. I don't think the stakes for my property, you see here, which is, if I'm not mistaken, this is where it all starts, is down at the bottom. That is actually my property, because it's washing into my property. Over here where you see the pink stake, that is his property.
Well, you
Ms. Vire, I'm sorry.
Yeah, you have two sets of photos, and these are not the photos that you showed when you were testifying.
All right.
They were the
I don't
black
know
and white
how-
photos.
Can you get me back over there?
Yeah, if we can show the original photos that included the property line designation and showed where the driveway was.
Let's see if this is over here. These.
Right there, yes.
Okay.
Now, please understand, my question is based upon this photo and a few others, that I do see the embankment, I do see the collapse of land, but it's all on the left side of those stakes that you say delineate your property on the right and your neighbor's property on the left.
Correct.
Is there a photograph that shows where your property, as evidenced by these stakes and property line, has collapsed?
I cannot, because these was taken when it first opened.
And this one here also shows that the collapse did not occur on your property, it's on the neighbor's property.
That is correct. That is correct, because these are the photos when it first started happening. This is when they actually came out and started. Now I'm testifying to this bank is no longer there. Where you see this concrete, the start of this concrete, and in the middle where you see almost a V, that is my property, and it is washing out.
Thank you.
Yes, sir.
Other board questions? Okay. Thank you so much.
I just have one
Please.
direct question for her.
they brought up a question of your usage of it and you didn't own the land. All the prior owners of that property have given you permissive use for you all to have that driveway to get to that, to get to your property. Is that, nobody has ever objected to that, am I correct?
That is
And
correct.
how many owners have there been?
To my knowledge, there have been 4 prior to Ms. Fire
And,
purchasing this property.
and the first time that she owned this property, we uploaded a copy of the deed was October 24, the 15th day of October 2024, is that correct?
That is correct.
Thank you. Nothing further.
Thank you. Anything further from the applicant based on that exchange?
Sorry, Mr. Chair. Mr. Ellison, do you want to enter those photographs that you
I
showed?
do, I want to enter the photographs. I know there's objection to the homeowners association document as potential hearsay, but rather they are admitted.
We can put them on the record with,
I'd
with your, with
like to put
the,
them on the record. In fact, all the documents that we submit, I'd like to have them put on the record.
Hearing no objections, so omitted. Thank you. And just to be clear, any other questions based on that exchange from the applicant? For her. No. Doesn't know? No, okay. Any further board questions based on that last exchange? No, okay. Members of the public who wish to speak on this as a witness, I need a show of hands who is here to speak as a witness. Anybody here to speak on this property, on this a variance application? For or against? Going twice, going 3 times, okay. Closing statements, we'll take it from Ms. Lytle first.
Just briefly, just,
can you speak in the microphone, please?
I'm sorry.
I'll just briefly say, I think it speaks for yourself looking at the photos of the damages occur, but I think the history of this property is also evident that there's obviously been some issues all along. Is it a hardship if you create the hardship by digging out the bank deeper than you should have, that now you need to move it forward because you created it and the damage is being caused? You know, when it comes to deterioration of land with water, that's not going to stop. The concrete crack in the pictures, those are real. And these pictures were taken earlier. That damage is going to continue. It's almost like trying to put a square in a circle, built for a 1-bedroom trailer that we're trying to put a 3 or 4-bedroom trailer in. There's just no space for it. And so it requires the cooperations of the neighbors. You can't get it, you can't get it. All of this should have been done in advance. I don't believe there's a risk of loss of $25,000 to buy a trailer because you won't grant them a variance. If they believe that, they would have gotten this variance in advance. They would have got a neighborhood agreement, had a right-of-way agreement to put in, to bring that trailer in. All of this would have been done in advance. A survey, a proper survey that would have done would expose all the problems. If you look at the exhibits we had admitted, look at the number of owners of that lot. There's a reason. It's because the shoe doesn't fit. Now, if you grant this variance, you're going to create a whole lot of more problems for all the neighbors there. Letting this go from 10 feet to 4 feet, it was put in 10 feet for a reason. Absent some great hardship that was not created by the petitioner, this hardship was created by the petitioner and the purchasers. So that's not the people that live there, that's not their fault. And I don't think it's your job here today to worry about the profits that'll be made by a mobile home dealer because he didn't do his homework. And so we ask you to deny this variance.
Okay, any closing remarks from the applicant?
Thank you. Yes, just in closing, everything that we've done was done in good faith. We had the site plan review approved, the permit approved, closing on the loan. All that was done in good faith. So what you're seeing in erosion is part of construction, and I think everyone knows during construction there's going to be erosion, but once the construction is completed and the finished grading is done, she's going to have a lot better access to her property, and I don't think she sees that big picture there. So there has been attempts to make sure that she does have entrance to her lot, and the fact that she can get her home if she chooses to remove that. So I think we presented everything that we've done in good faith, and I hope you grant this variance. Appreciate it.
Thank you. This time the public hearing is closed, and we will move to board discussion and deliberation. And just a general note, we've talked about a lot of different aspects of this and gone astray a couple or three times. But the board is obviously concerned with whether it's appropriate to grant this variance based on the requirements in the ordinance and based on the testimony presented, within the parameters of whether a front variance should be granted. The other issues aren't particularly relevant to our decision-making. So comments, questions, thoughts?
The only opposition to the variance, the only stated reason for not granting the variance is based upon the one neighbor. I haven't heard anything else that really ties to the variance. And the one statement that Ms. Lytle made, that if she were to have access to the property and that we did not have this easement issue, she would not be opposed to the variance, leads me to believe that there really is no opposition to the variance. This is about access to the property and the lack of an easement. And for that reason, I support the variance.
Yes, sir, Mr. Gonzalez.
Yeah, to me, the issue, well, first of all, it's kind of a mess, okay? And I think Mr. Ellis put it clear. Why do you buy a house if you can't get on the property? Okay? But my feeling about it is, seeing the damage on her property, and that, speaking for the applicant, said, well, during construction, erosion is acceptable. But I didn't see any, in the picture, any of the erosion barriers.
Mhm.
And when you do construction, or your friend who did the excavation put those up. So my concern is what's going on her property with this going on. I personally feel there should have been steps taken.
Joel, I just want to make sure that you are aware that they are not required under our ordinance to have any erosion control or any barriers. The site's under 1 acre.
Okay.
So I just want to make that point.
So you preface this, I am not an erosion control officer. However, even when there's no permit like for an erosion control, which would only be required for over an acre, best erosion control practices still must be there. You have to keep dirt on your property to some reasonable degree. But, just as a reminder, I don't know about the topography here, but silt fences, that's only on downhill slopes. So if you'd be grading up here and then the dirt be going downhill. So if it was an uphill, you wouldn't see a silt fence necessarily. But I don't know what the topography is on there.
Well, for the excavation, do you need a permit to start that?
Well, it's still just land disturbance, so as long as it's under an acre. This is a single-family lot of 0.28 acres, so it's not in any flood hazard area or anything like that, or any zoning overlay.
Right.
They don't need any special erosion control permit. The site plan review was approved. It was approved in error by zoning, but erosion control, signed off on that as well. So, they have their standard comment on that approval as well.
Okay, but that's
for
an
the erosion control
assumption
purposes.
that what is happening on that lot is not going to end up damages on someone else's lot next door.
Correct. That's true.
Okay. So I don't know.
Andy, I got a couple
Please.
thoughts on this. You know, there's been a lot of conversation on this particular variance, but, you know, the board, we're charged with a four-way test on to grant a variance, and it's pretty black and white in my view, and we've talked about that. This particular variance, you know, when you look at all the different metrics that we have to hit, the hardship that did not result from actions taken by the applicant or property owner does seem to be, you know, we kind of fall into that. They relied on experts to prepare a site plan. It was approved. There was a building permit issued. There were things that were taken without their, you know, they relied on other experts to make this decision. The hardship they're facing now is not of their doing. All the other issues aside are not really purview of the variance request that's before us. I think, given that and given the circumstances with the permit being issued, that gave them the assurance to go to a loan closing, you know, et cetera, that, you know, we are in a position where that we should just, I think the variance is justified.
I think that language in that variance provision about, you know, strict application of the ordinance causing an undue hardship on the applicant, that applies here especially too, in addition to what you just said. I couldn't agree more, so. Other thoughts? Comments, thoughts? Yes, sir.
We've all seen a few cases where an applicant acted in good faith based on an error that was made by a planning department, and in situations like that, my tendency is to go with the applicant, which I do in this case.
The issue, we require how many of this panel?
For, it's 80%, 6, yeah.
Be a supermajority.
So ready for a motion, sounds like whenever, unless there are other comments. Do y'all have sheets over here? All's up.
I'll get it.
You got it?
Mr. Chair,
Okay.
based upon the evidence presented to this board, including the following exhibits, the petitioner's application, submitted site plan, the GIS maps, the staff report, testimony presented at this hearing, I move that this board adopt the following findings of fact. This matter is properly advertised within the board's jurisdiction, is ripe for its consideration, that this application, together with the conditions proposed by staff and/or this board, and agreed to by this applicant, does meet the requirements for granting a variance contained in Buncombe County Code of Ordinances, Section 78-621, Paragraph 4.
There's been a motion to approve. Is there a second?
Second.
Is there a motion and a second? All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes unanimously. Is there a second motion?
All right, Mr. Chair, based upon the foregoing findings of fact and for the reasons set forth therein, I move that this requested variance be approved and that the staff be instructed to draft an order consistent with this motion approving the permit and any agreed-upon conditions for review and execution by the chair, acting chair, or such person's designee on behalf of this board.
There's been a second motion. Is there a second to that?
Second.
Okay. All those in favor, please say aye.
Aye.
Any opposed, nay? That passes unanimously. Thank you so much. We'll move to the reading of an order on this case and approval on that, and then we'll do a short 5-minute break. Yeah.
Oh, crud, that was the wrong, shoot. Yeah, excuse me, folks, we're still in session.
Yeah, if you have conversations, please take them outside. Thank you.
All right, Mr. Chair, members of the board, I have the following proposed order in this matter. Is it up? I'll try to make it bigger. All right, I'm going, I know we got a full room. So that this matter was before the board is right for consideration. All proper notices were made that the applicant is requesting a variance pursuant to section 78, 621, subparagraph 4, and 78, 642, table 2 for the dimensional requirements at 90 Hazelwood Road, that at the hearing, the applicant and any parties withstanding were given an opportunity to offer both oral and testimonial evidence, that an unnecessary hardship would result from a strict application of the zoning ordinance. The hardship does result from conditions that are particular to the property. The hardship did not result from actions taken by the applicant or the property owner, and that the requested variance is consistent with the spirit and intent of the ordinance, such that public safety is secured and substantial justice would be achieved in granting the same. There are no conditions on this variance, and that based on the foregoing findings of fact, the board makes the following conclusions of law: that the application, together with the conditions, satisfy the requirements for granting a variance contained in the zoning ordinance, and that based on the findings of fact and conclusions of law, that the applicant's request is granted as requested in the variance. And that's it.
Any questions, comments, or a motion on the order? Move to accept. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you so much. Appreciate that. 5-minute break. Thank you.
Hey, Gene, can you come up here for a second?
Good afternoon and welcome again. Good afternoon and welcome again. All conversations outside right now. Thank you. Thank you. Welcome back to session. We've got ZPH 2025-00039, the Leicester Stump Special Use Permit. And we're going to move in a little bit of a reverse order today than usual. So we'll start, instead with the staff report, we'll start with standing applications. So if staff will, if you want to introduce this first.
I believe that the attorneys have been discussing, and I think I will let them explain what's going on.
Good afternoon, sir.
Yes, Mr. Chair, members of the board, Clint Cogburn of Ward & Smith here on behalf of the applicant. I have been in contact with Billy Clark, who represents, to my knowledge, not every applicant for standing, but a good subset of the applicants for standing, and that he has spoken with those individuals, including his clients and those that he does not represent. And I believe we've come to an agreement on 6 properties that we would consent to being granted standing in exchange for the remaining applicants waiving their application for standing. I can read off those properties. It's the Ruckel property, Hoffman, McDowell, Snelson, Lusk, and Morris. Billy, did I identify those?
That's right. For clarification, it's Bill McDowell and his wife is Ashley Wall, but it's one property. And that is, Mr. Cogburn's representation is correct.
And can you read off those names one more time for us?
Yeah, so it would be Ruckel, Hoffman, which is, there are 2 Hoffmans, which to my understanding, it is a married couple, but it is one property. The McDowell Wall property, again, a single property. Those are, again, to my knowledge, a married couple. Snelson, Lusk, and Morris. And so we, as Morris, Wilma Morris. And so as part of this, we would be willing to consent to that, subject to obviously confirmation of the waiver of the remaining standing applications.
Okay.
As part of that waiver, we would recognize that those folks could speak as witnesses, as I know the board allows, even if they were to be denied standing.
And to be clear, this conversation has taken place amongst everyone who has applied for standing already with the board?
With all the people.
Or everybody in the neighborhood?
With all the people that I represent and a number of people that I don't represent, we just gathered in the room a few minutes ago. And some people who were here earlier had to leave, and I don't represent them, but the understanding is that these 6 properties will have standing and everyone else will be free to testify as a witness or witnesses.
Okay, so that we're crystal clear on this, is staff aware that everyone who applied for standing with us was a part of that conversation in the room?
I think what we should do, my recommendation would be is obviously we have the 6 that have consented. You all can then make a motion to grant them standing. Then I think what we should do is call out each individual applicant and ask whether they withdraw their standing application.
After that's done.
And then we can move from that. How does that sound?
So I would propose doing it in reverse, just because our consent to those 6, we do believe we could have challenges to some of those, if not all of those 6. But we would waive those challenges and consent to them if the remaining applicants waive standing.
Okay, so we have the Hoffman are part of the group, the 2 Hoffman applications, the Snelson application, the Ruckel application, and the McDowell application. Oh, and
Wilma Morris.
Wilma Morris, okay.
And the Lusk application.
The Lusk and the Morris application. All right, so I guess the first person that we will ask, and I'm just going to go, it might be easier if we go into the audience, I will go into the audience and Griffin will call out their name and we will ask them whether they withdraw their application. Does that sound
perfect.
Okay with the board?
And as part of that withdrawal, you would agree that that you could come whenever it is, today or tomorrow, today or next meeting, for a witness testimony as part of this.
Okay, so the first application I have that, to our knowledge, is not a client of Mr. Clark is Morgan Curtis Boyd, Jr.
Are you in the audience? Are you okay? Are you withdrawing your standing application?
No, I'm here to say something.
Right, so let me just explain to the audience that if you are granted standing, you are acting as almost a party to this action. Okay, so you would be acting as a pro se plaintiff. So that you could ask questions of witnesses and things like that. The other difference is that we also allow witness testimony, okay? So at the end of this, you can come up and state whatever you basically want to state as long as it's relevant to the case. However, you do not have the ability to cross-examine witnesses, and you are not considered a party to the case. In order to be granted standing, you have to show that the damages to your property are somehow special and different from the remaining property, or from the remaining community. I'm sorry. So you actually have a fairly high bar to establish standing, and then we will call you up and you can try to establish that. Does that help clarify or answer your question? Or
Okay, I can speak pro or con correctly.
yes, you will all be
Yeah.
able to speak and
And during the witness period, yeah.
state and present evidence, but you are not able to basically act as a pro se attorney
And
on
prese-
your
and
behalf.
present a case, call witnesses, all that stuff. Yeah.
So sir, do you wish to withdraw your standing application?
No.
Okay.
Okay.
All right.
Moving to
Well,
the next
have
thing?
set. We'll get to the next one.
Yeah.
Just to confirm on the procedure we're following here, we are going to individually ask each of the standing applicants whether they are withdrawing, and then conduct the standing hearings for those who are not withdrawing?
Yes.
Yes, except
Okay.
for the 8 that were identified prior.
So, all right, I'm going to have to make,
Right. We will call you up and you will present your case as to whether you have special damages or not. Okay?
okay.
Next.
The next one is Patricia Darrow.
Do you wish to withdraw your standing application? No. Okay. Next.
Next is Angela Price.
Do you wish to withdraw your standing application?
No, I do not.
All right. So, how about we do this? Since it seems like none of you are wanting to withdraw your standing application, is there anybody that had applied for standing and is wanting to withdraw your standing applications? Please raise your hand.
Okay? He wants to add to it. Add to it.
All right, we'll add you to the list.
Leslie Ty and Randall Ty. Last name is Tighe.
And you were wanting to withdraw your standing application.
Correct. Yes, we are wanting to withdraw.
Thank you.
All right. Is there anybody else?
Yeah, there were like 3.
Okay. I'll just move along. Sir, what's your name?
Francisco Rodriguez.
All right, Mr. Rodriguez, do you wish to withdraw your standing application?
Yes, I do.
Thank you. God, I feel like Jerry Springer. All right, next. Hey!
You
All
look
right,
like Jerry
next,
Springer.
ma'am.
No.
Yes, you still have the ability to come and testify as a witness. You just cannot
end of the hearing.
cross-examine and basically act as a pro se attorney, more or less.
Sarah Fielding, I withdraw my application.
Thank you, Ms. Fielding. All right, is there anybody else? Oh, I'm sorry.
Sam Pike, and I withdraw my standing.
Sam Pike, thank you very much. And sir?
Chris Foote, and I withdraw my standing application.
All right.
You getting
Is
these,
there-
Griffin?
Are you okay, Griffin?
Getting these? Okay.
All right.
I think we're all set, except for the gentleman who wants to add on to the pile.
Right. Well, they can testify and they can represent themselves. If you are going to represent their interests, you may be engaging in unauthorized practice of law. So I do not. Well, if you have a lawyer that can do that, are you with Mr. Clark or Mr. Snow? Okay. So yeah, you can still speak as a witness. Yes. Okay. Is there anybody else?
I'm Heather McCurry, and I need to withdraw my standing.
Okay.
Heather McCurry is withdrawing her standing application? Thank you. All right, anybody else?
And then let's just get this guy's information, this gentleman who wanted to add on as a standing applicant.
Who?
Gentleman in second row.
Do we have a paper standing application that we can get him to fill out?
We can get one.
Mr. Chair, can I
Print out
ask you
an
questions
application
about
and you
this?
can fill that out.
When we have these 6 people here who they all agreed that should be given standing, are we to take from that all 6 of those people have separate individual and unique objections apart from the other 5? Or are we to say that all have the same objection, which isn't my understanding the way standing works?
There's 8 who will be represented who have applied, not been heard yet on that, and they will have different issues, yes.
Okay, so all 8 have different issues.
I would assume. We'll hear about that later during the hearing.
Okay, but the attorney would agree to that? All 8?
We're not there yet in the process.
there yet,
We're not
okay.
there yet. So we're trying to eliminate everybody else on the list and categorize them and then move on to their standing application.
Okay, so
We'll
we
get
still
there.
have to listen to
Oh,
all
yeah.
8 of those people?
Oh, yeah.
Oh, we do, okay.
Oh, yeah.
Well, I think that if both parties consent, we don't need to, but I'm not sure
Well,
what's
I'm
going to
sorry, we
happen.
have to find standing for them, yes. This would be a hearing for standing for those 8. Yeah?
Right, but I think that I think the idea is that that there would not be an objection to you granting them standing.
Right, but we still have to grant them
by
standing.
each of the parties, whereas you have, I don't
Correct.
think you need to qualify if there's a consent, but I don't know what's going to happen now.
Yeah,
You're right.
that was the goal in terms of trying to, again, come to an agreement as to certain property owners that,
For those that
again,
were represented,
we believe that we could challenge for standing, but we're willing to consent to standing if, in exchange for that, the remaining applicants would waive their standing.
I think everybody's on the same page with that.
so-
We're going to get there, but we want to make sure nobody else, aside from those
But
who are represented.
it appears that.
Are you saying to us that everybody in the room has to say no?
Yeah.
Correct. That
okay.
was my understanding coming into it, and was what was represented to this board. I don't know if some additional. I will have to defer to Mr. Clark on whether any additional time may get us there. Otherwise, we'll have to go through these standing applications. Again, the proposal was to try to avoid protracted standing in exchange for recognizing a subset of property owners. That has not been achieved here.
That's correct. And probably won't. So I think we have to go to a hearing for that. With you representing, of course, the 8 that have agreed to sign on with you. Yeah.
Right, we could try to take a few minutes to see if we can get some waiver, but I'm not sure how productive it would be.
Griffin, can you give us an idea of where we are on the count now that we've had some people fall off? Sure, yeah. Just to know where we are. If we have 8 that are represented and then, 17 that aren't, that want to speak, that's, not going to happen.
So that would be 13, not counting the clients of Mr. Clark or the individuals who withdrew.
And Mr. Chair, I know that there was at least some mention by Mr. Clark that some of those individuals may have left. I don't know if that may help to narrow it. Just trying to get to an end result
Of the
here.
13? Sorry, people may have left of the 13 remaining?
That is what I heard from Mr. Clark.
I'm not sure of that 13 who left.
Okay.
I mean, we'll just go through if they're not here, they're not
Before we
here.
do that, can we go ahead and name those 13, those surnames, and get a show of hands? So when they call your last name, if you'll raise your hand, please.
Okay, so that they would be Boyd, Darrow, Price,
We got them. Yep.
Chitwood, Peters Limbeck, Seifert, Knapp, Brackens, Leonard, Marshall, Griffith, Hahn, and Avallo.
All the names after Peters were not, no hands showed. Standing. Okay.
And what's your last name?
That's the pre-submitted, if you, before today, you submitted standing applica, request. No, they're not
That
included.
excluded anyone who was represented
Not
by
included.
Mr. Clark.
So we're
And it
gonna-
excludes any of the people who withdrew their standing
If you will,
applications.
let's go ahead and hand that new application out to that gentleman, and of course, this one as well, in the gray sweatshirt over there. And then, if Griffin, one more time, if you will, read those from Peters on that are presumed not to be here to assert standing. So if your name is called, you don't raise your hand, or raise your hand when your name is called, and if you're not here, then you can't assert standing.
And
So-
I'm just gonna, for clarity's sake, gonna start from the beginning of that list.
Okay.
Boyd, Darrow, Price, Chitwood, Peters Limbeck, Seifert, Knapp, Brackens, Leonard, Marshall, Griffith, Hahn, and Avallo.
Everyone from Peters Limbeck on can be presumed to be not here.
It looks like we have 4 people outside of the.
4.
Yeah.
And then a 5th signing right now.
Our
And then
5th is filling out an
Sir, with
application.
sir in the third row that we just talked, yeah, where you wanted to assert standing in this matter. Oh, you're one of the 6, yeah. Oh, I got you now. Thank you, sir. Appreciate you, yeah. Thanks for
Mr. Chair,
clarification. Yes.
can we get clarity on what those 4 names are? I've got Boyd, Darrow, Price,
And sir?
and Chitwood.
Let's just put this out there. Should we take 3 minutes and have a conversation about whether those 4 want to be included in this or not?
I would be willing to take 5 to 10 minutes to see if we can resolve it. I think that's good
That would
time.
just smooth the process along. It's
Yeah.
really, it gets really.
It's going to take us more than
But
5
we're not-
minutes to go through a witness. so-
Correct. So we'd be willing to take 10 minutes to see if we can
Okay.
resolve that.
And to be clear for the members of the public here, you do not have to sign on, of course. We're just trying to consolidate where we can and make it a lot shorter and cleaner. But if you don't want to be represented and want to start standing on your own, you may.
Thank you, we'll do that.
Is that right?
Right.
Okay. Thank you. 5 minutes. Thank you, thank you, thank you. Thank you, and we'll reconvene. All right. So, Mr. Clark, do we have a revised list from you?
We do, Your Honor, excuse me, Mr. Chairman. I spoke with Morgan Boyd, with Tricia Darrow, with Angela Price, with Harry Chitwood, with David Underwood, and Heather McCurry. All of them have agreed to waive standing. I also spoke with Cara Beth Brackens on the telephone. She's the head mistress or head person of the school that's going to buy some property from a property located out there, and she agreed to waive standing as well. This is with all with the understanding they can appear and testify as witnesses.
Okay, great. Will you be representing? They're withdrawing, so not going to be part of your slate.
I don't represent any of those individuals at this
Got it.
time, but I did speak with them, and they're all here in the audience except for Ms. Brackens, but she has a representative here too who can confirm that, because he called her on his cell phone when I
Okay.
spoke with her.
So just to be sure, with members of the audience that did want to assert, do you all agree with that, sir? Yes. Okay, great. Thank you very much for working with us. We do appreciate it.
Okay, so just to get on the record, does the applicant agree with the proposal as reached?
Yes, given that with those representations by Mr. Clark and by those members in the audience who had applied for standing, we would consent then to standing for, again, Ruckel, Hoffman, which is two individuals, McDowell and Waugh, which again is one property owned by a married couple, Snelson, Lusk, and Morris.
With that said, is there a motion from the board to grant standing for those members just mentioned? No, there's not a motion from you, okay. Is there a motion from anybody to grant standing?
Motion to grant standing.
Okay. Is there a second to that motion?
Second.
And to be clear, we had a motion and a second. We can grant standing without the full hearing with that agreement, correct?
You can.
Okay. All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? Nay. Okay. Thank you. That vote's recorded. And we'll move forward with the staff
I think
report.
the next thing
Yeah.
before we get to the staff is I believe Mr. Clark has a motion to continue that we
Let's do
probably
that
want to
then.
address before we get into that.
Yeah, Your Honor, thank you, thank Mr. Chairman Ball. I apologize for that mistake. I filed a motion yesterday to continue the hearing. I know we weren't going to hear it till today. The motion is filed on behalf of Bruce Nelson, Bill McDowell, and wife Sharon Waugh, Clementine and Lionel Sawyer, Chris Lusk, Roy Lusk, Norman Hoffman, Wilma Morris, Gary Lusk, David Underwood, and we would move to continue this hearing from the Board of Adjustment till the next meeting of the Board of Adjustment. First of all, notice was timely and proper, but given the time of year, it was pretty short, and most people didn't find out about this until last week. We did have a public meeting, remote public meeting facilitated and organized by the developer, and they provided useful information. They provided a lot of information. Then yesterday, after I filed this motion to continue, Mr. Cogburn sent me a lot more information, about 650 pages of it. So we just need time to review the information they provided already, and we need time to consult with some people on property value issues and traffic issues and noise and dust and fire issues related to operation of the proposed dump. And we've also, we are making available, we'll make available the Newfound Baptist Church has a large meeting room. They have some rules about no profanity and stuff, but we would be glad to work with the developer to host a meeting there to, if there are any more questions between now and then. We know it's not required, we're just offering that. So we would move that the matter be continued. It's the first time it's been on the Board of Adjustments agenda, and would appreciate the board's consideration of that motion.
As part of that request, will you all be planning in the next month or so to call expert witnesses in various areas?
Yes,
Okay, so that would be a reason for more time.
that would be a reason for more time, yeah.
Comments, thoughts?
Yes, Mr. Chair, and Mr. Clark's summary is accurate in terms of the communications we had. We have tried to be as responsive to Mr. Clark and his clients as we can, including holding the virtual meeting on Monday to provide additional information to the community. We're not able to consent to the continuance. We do recognize that it is a first request for a continuance in this matter. We do also acknowledge the time of day in relation to this hearing, with it being past 3 o'clock. But my clients are ready to move forward. We do have our engineer here. We are prepared to proceed. It was properly noticed, as Mr. Clark conceded. And so we're ready to move forward. There are also some business implications for my folks in terms of having this timely heard. That being said, we do recognize that granting the continuance or denying the continuance is in the discretion of the board. We would ask that if the board were to elect to grant it, that as part of that, we just clarify that standing has been closed so that we're not receiving any additional standing applications before the next meeting if it is continued. And also looking to try to get through the case at the next meeting. I know that obviously some of that is subject to what occurs, but we would just ask that that the parties do their best to keep presentations tight so that we can try to get it through at the next meeting.
And the documents referred to a minute ago that were sent over in the last couple of days, those are part of your presentation to the board at the hearing. Is that correct? Is that the intent?
Yes, it is. Those are the documents we submitted 5 business days prior to the hearing. We submitted them to Griffin, I believe, on last Wednesday in accordance with the bylaws. I would have to defer to Billy. Billy reached out either on Thursday or Friday of last week to relay that he was being retained. He was not sure who he was being retained by at that point, but that he was in the process of being retained. As soon as we had clarity on that, we did provide him with the documents and have maintained regular communication with him. So we tried to be, again, as transparent as possible in providing those documents.
And if we could ask before the next hearing that, I guess staff send a reminder, it's required, of course, but that we go ahead and ask all parties to submit any documentation you plan to present at the hearing 5 days in advance, so that we can get it uploaded for the public and all of that.
And that would be expert reports or anything like that, so just that you know that you need to get those to us by.
And my understanding of the bylaws as well is that it's supposed to be exchanged with council as well. So
Yes, please.
We understand things come up and the things come in last minute, but if that happens, we'll
we
judge
can
at
work
the
to
time,
resolve
but-
it. Yeah.
Yeah.
May I ask when the next meeting is?
It's usually the second Wednesday, so it would be the second Wednesday in February.
Okay.
I don't know the exact date, the 11th.
Thank you.
So let's start with the board, asking the board to close the standing portion of the hearing. Is there a motion to close standing?
Question?
Mhm.
If we were to start with the applicants for standing, that's not going to be done by the end of the day.
I would think not with the time that we have. Yeah.
So that's going to kick this next month anyway.
Yes.
But we could get through a couple of
We could.
applicants for standing.
Yeah, Mr. Chair, I would agree with that. Any administrative stuff that we could do up until 4 o'clock, I would suggest we do.
I am under the impression that there are no outstanding applications for standing and that we've resolved all that. Is there anybody else in the audience that is wishing to assert standing at this time that has not? Because
Yeah,
under our
we're
rules,
done.
people need to file 24 hours ahead of time. So I think we've resolved all the standing applications. So we're done with that portion.
Yeah, let me clarify. The intent of that motion, of that ask was this, that we close it.
Right,
process
so that-
now,
so that
everybody
people-
knows that if they come next month for the hearing, they can't assert standing. They cannot.
Exactly, and I think we've
They
done
speak as a
that in the
witness
past.
later on.
We've done that in the past.
Yeah, we should do that this time, so, if the board's okay with that. Yeah.
So moved.
So moved. Is there a second?
Second.
All those in favor, please say aye. Aye. Any opposed, nay? That passes. Okay. On the hearing, does the board wish to go forward and begin to hear the applicant's case?
Yes.
Okay, okay.
Yes.
Everybody good? All right. We're good to go if y'all are. We'll start with the staff report.
So So you are so I think that you need to make a motion to either grant or deny the motion to continue.
Okay. Is there a motion on the continuation of the meeting?
Mr.
We can
Chair.
continue in the middle of a meeting, right? We don't have to continue the entire.
There's been a motion by one of the parties that we continue it. So we're going to ask for board for a vote on that. To deny. Yes.
So I also just want to be clear. I have concerns, and I understand that this may go against what I had mentioned in relation to the continuance. But if we move forward, I certainly want to not. We would be presenting part of our case in chief. They would get essentially a look at that case in chief as part of this, and then I just worry that it would provide them with a potential unfair advantage of then being afforded additional time. So it. Keep
it down, everybody.
What I
will be excuse me, Counselor. You will be removed from this meeting if there's another outburst like that. And we're taking notes. We see who's laughing. No outburst at all. Seriously.
Kind of a middle ground that I could potentially propose here would be to have staff present its report, and then we continue the matter to next month. That way we get through staff's report. We get to a portion of it that will take us close to the 4 p.m. End of this meeting, and then we would continue it.
Let's have the board take that into consideration here, but let's go ahead and discuss and decide whether we continue or not. I agree with those who said we should continue and start the case today. So,
With 45 minutes left?
yeah, it's enough time just to get started. Yeah. Everybody good to go? Okay. So is there a motion on continuation of the case that was made?
So there's a motion, is there a motion to grant or deny?
There was a motion to continue the case. All those in favor, please say aye.
Aye.
Is there, okay.
Hold on, raise your hands.
Let's raise
That
our
might be
hands for
helpful.
this vote.
Who is in favor of continuing the case till next?
So I'm so sorry. Let me clarify. To continue the case to a date certain to the next meeting.
Oh, okay, that means this meeting is going
Grant
to
a
end
continuation
now?
of the case.
Yes.
Grant a
And
continuation
also,
of the case to
is
next
this
meeting.
a motion to continue it after the staff
report.
presentation,
And to
or to
adjourn right
continue
now.
it immediately?
Right.
Right now, and adjourn the meeting?
Right.
Right
Okay,
now.
the latter is what you're saying.
Not right now, no. To continue the case, which is a continuation.
Right, but I think
To
the
abbreviate right now.
I think the question is that, do you want to, so I guess you have a couple options. Number one is to not continue and just move forward and try to get as much as we can done before 4 o'clock. Option A. Option B is to grant a partial continuance where we allow staff to do the staff presentation, and then each party can cross-examine staff, and then end it and continue it after staff's presentation, regardless of whether we get to 4 or not. That's option B. Option C is to continue the case right now, not start it, and then do everything in the April, start the hearing in the April meeting.
Thank you for the clarification on that. So there is a motion before the board to consider and vote on whether we continue the case to next month. And so if you vote no on that.
I'm sorry, Kurt just said
Vote yes
April.
on that, you want to continue to next month. If you vote no on that,
Really apologize. It would be
He's
continued to
clarifying your
February.
options.
I've had a
clarifying
long
your
day,
options.
Paul. So,
there's, the party withstanding has asserted a motion to continue the case to next month. If you're for that, you say yes. If you're for continuing today with the case, you say no. You want to continue today with the case. Not, yeah, today. If you want to abbreviate the meeting and go home and have them continue to next month, that's a yes. Right?
Okay, so go up until 4 o'clock is a no.
Maybe we should back
To 4 o'clock, yeah.
Yeah, okay.
That's a no for 4 o'clock.
Can we just put forth a motion to continue the meeting with the presentation of staff report, after which we will bring forth another motion, continue it for the rest?
Option B.
It's option B, exactly.
You want to
It's all
hear,
the same thing.
you want to hear staff report now, then vote on whether we continue? Okay, let's do that. Let's do that.
All right, Mr. Chair,
Let's
I'll
hear-
make a motion that we hear staff report and presentation, allow time for questions and cross-examination, and at that time, we will continue the hearing until a date certain in February.
Okay. There's been a motion. We're going to hear staff report, then continue to next month with the start of the case. Okay, so that'd be a continuation. granting the standing applicant's request? Okay. All those in favor, please raise your hand. All those opposed? Thank you. Yeah. So that vote's recorded. We will ask staff to present the staff report on this case. Sorry. I thought we were continuing. I did. I thought we wanted to continue. It's option B. It's option C.
Please raise your right hand and state your name.
Dana Alley.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask all applicant and staff materials be accepted into the record as evidence.
Hearing no objection, so omitted.
This is the review of ZPH 2025-00039 Leicester Stump Dump. Applicant is Warren Sugg of Civil Design Concepts with Riverside Stump Dump Incorporated. Property is located at 7 Brookshire Road. This property has one single-family home, which will serve as the office for the project, and it's serviced by well and septic. Property is zoned open use. Project proposes a stump dump for processing vegetative brush and turning it into mulch. Under our zoning ordinance, this is considered a solid waste, it's not processing facility, management facility, excuse me. There are no deviations required or requested. If approved by the board, staff recommends the following conditions of approval, which I will summarize. All parcels included in the development must be recombined before submission of the site plan review permit. Permits from NCDEQ and NCDOT must be obtained and provided to Buncombe County as part of the site plan review permit. Project must be constructed as depicted in site plan.
Thank you very much. Questions from the board for staff today?
And what is it that drives this conversation to the board? Why is this case relevant to the board?
It has special requirements as a solid waste maintenance facility.
Okay.
It doesn't come with a set of findings that we have to make besides the usual findings?
No.
Just that we approve it? Okay.
What other authorities are going to be involved in the final approval of this case?
It'll go through the regular site plan review process, so environmental, erosion control, stormwater, basics like that it usually goes through. But it does have to go to DEQ before it can even be brought to us for that site plan review.
And DEQ is?
At the North Carolina Department of Environmental Quality.
Okay.
The materials to be processed, and I don't know if you could answer this, where do they come from?
I can't answer that.
Any other questions? Good. Thank you so much. We appreciate it.
Oh, hold on. You may want to see whether the
Yes.
parties have any questions.
Okay.
I just have one question for clarification. You mentioned in your testimony that the 7 Brookshire Road property is included. Is it also correct that there are 3 other properties located along New Leicester Highway that I believe are all unaddressed that are included as part of the request?
That's correct. Those must be recombined.
It's Billy Clark. I'm the attorney for the approved people with standing. Do you, what information did you review prior to making your staff report?
We received site plans and we received the level 1 application.
Okay, and did you have any conversations with the developer or the engineer for the developer?
We submitted comments back to Warren Sugg, but I have not spoken directly with the applicants.
Okay, and those comments are in that letter that he wrote with the red?
That's correct.
Okay. Is this the first special use permit the county has issued for, I'll call it a stump dump?
I'm not aware immediately if there are others. I don't believe so.
Okay. Have you reviewed information supporting an application for a stump dump on other occasions?
I have not.
Okay. Tell me about the suggested special conditions. You say, I'm sorry. Do you have any involvement with getting the permit from NCDEQ?
Do I have any what? I'm sorry.
Do you have any involvement in getting with
No, I
the
do not.
DEQ permit? Okay. And when you say must be constructed as depicted in the site plan, it's my understanding there's not going to be any additional buildings. It's just going to be the land grounds, if you will. Is that right?
That's right.
Okay. Did you, in making your evaluation, did you consider any issues relating to possibly increased traffic?
No, it was not required for a traffic impact analysis.
Okay. Did you review any conditions or any issues regarding potential noise from the operation?
We do not enforce noise. That's by the sheriff's department.
Okay. Did you review any issues relating to the potential for fire from a stump dump?
That is not considered as part of the review.
Okay. What is considered as part of the review?
I think I would rely back on the zoning administrator for clarification.
Are you about to testify?
Why don't we finish up with Dana, and then if we need to call another staff, we can do that? If you can't answer that question, just let them know, and we'll find somebody who can.
Cannot answer that at this time.
Was any information provided to you for your review about the types of material that would be coming into the stump dump?
No, vegetative brush is the description that was provided.
Okay. And you didn't make any further investigation about that?
No, that can't be enforced under the zoning ordinance.
Okay. I think those would be all the questions I have for you. Thank you so much.
Any cross?
Yes, just brief kind of redirect or recross. You had mentioned that staff doesn't have any involvement in relation to securing the NCDEQ permit. Is it correct, though, that a site plan would not be issued unless the applicant obtains an NCDEQ permit prior to applying for that site plan approval?
That's correct. It must be submitted up front with the site plan review.
And so the county would not approve a site plan that does not have a approved NCDEQ permit.
Right.
Mr. Clark had asked about reviewing traffic. Is it correct in the comments provided in the TRC process that staff noted that this would require a NCDOT driveway permit?
Yes, they do have to obtain that.
So there would be some review in relation to the access points proposed for the site.
Please raise your right hand and state your name.
Savannah Glantz.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
Yes. I believe
Ms.
so.
Glantz, can you tell me what your position is with the Buncombe County?
Yes, zoning administrator.
Okay. And the property in question here is currently zoned open use, is that right?
Yes.
Okay. And in order to get a facility processing organic vegetative waste, in order to operate in an open use area, zoned open use, it has to get a special use permit, is that right?
Correct.
And what are the requirements for getting a special use permit?
You'll bear with me just one moment. All right, per the zoning code, excuse me,
For the special use permit, all it states is a solid waste management facility used for the disposal of solid waste shall meet the requirements and specifications of the NC Department of Environment, and Natural Resources. The set approved plans shall be submitted along with the application for the special use permit. Those are the only standards that we would review.
And that are in the Buncombe County zoning ordinance?
Correct.
So were those reviewed in this case?
Yes.
Okay. Can you read that to me one more time, the requirement zoning ordinance?
Definitely. So solid waste management facility states that all solid waste management facilities used for the disposal of solid waste shall meet the requirements and specifications of the NC Department of Environment and Natural Resources. A set of approved plans shall be submitted along with the application for the special use permit.
Are you familiar with the North Carolina Department of Environmental Quality permit conditions and requirements?
No.
Okay. Is somebody with Buncombe County familiar with those?
Not that I'm aware of.
So is the condition in this, the staff, or the, I guess it's the condition in the staff recommendation that this, that the applicant obtain a permit from the North Carolina Department of Environmental Quality, is that how it meets that part of the county zoning ordinance?
Correct.
Okay. I think those are all the questions I have. Thank you.
Everybody else set?
No questions.
Okay, thank you. It's all the business we need to take care of with this case, so let's go ahead and proceed to a motion. Is that all that staff has currently? Okay,
Motion to continue the case until a stated or a date statement certain?
to the regular meeting next month. Yeah, okay. Motion to continue to the regular meeting next month. Is there a second? All those in favor, please say aye. Aye. Any opposed, nay? That passes. Thank you so much. Any other items from staff today? From the board? All right, is there a motion?
Motion to adjourn?
A second?
Second.
All right, all those in favor, please say aye. Aye. Any opposed, nay? We're passed. Thank you.